Good morning, everybody. I'm David Barish, Chairman of the Pennsylvania Gaming Control Board. Before we begin, as always, I'll give you your Miranda warnings about turning off your electronic devices or putting them on silent. Today, with us today are Fred Strathmeyer, representing Russell Redding, Secretary of the Department of Agriculture, Jennifer Langen, representing Joe Torsella, State Treasurer, and Bob Coyne, representing Revenue Secretary Dan Hassel. Thanks all of you for coming. Quorum of the board being present, I'll call these proceedings to order. First order of business, Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Today we have an oral argument scheduled pertaining to Bally Gaming's petition to intervene in the petition of Celebra HK Company Limited to confirm status as an institutional investor. May we have counsel for Bally's Celebra OEC come forward. Before we begin, I'd like each attorney making an argument today to please state and spell their name for the court reporter.
Good morning, Mr. Chairman, members of the Commission. Stephen D. Schreier with the law firm of Blank Rome on behalf of Celebra HK Company Limited.
Thank you.
Morning, Mr. Chairman. John Sirocco, S-O-R-O-K-O, Wayne Morris, on behalf of the petitioner, Bally Gaming.
Okay, thank you.
Good morning, Mr. Chairman and members of the board. Ashley Gabriel, Gabriel, G-A-B-R-I-E-L-L-E, for OEC.
Thank you. As you are the petitioner here, Bally, you may proceed.
Thank you, Mr. Chairman. With me also this morning is Mr. Michael Fries, Vice President of Compliance and Regulatory Affairs for Scientific Games, the parent of Bally.
Thank you.
May it please the board. Before the board is Bally's petition to intervene in the matter of the petition of Celebra HK Company Limited in respect of a determination by this board of Celebra's status as an institutional investor. Celebra owns nearly 10% of the shares of Bally's parent, Scientific Games. The matter's before the board because in June, the OEC advised Celebra that it was required to file either a principal entity license application or, in the alternative, file a petition to have its status confirmed as an institutional investor. Celebra chose to do the latter. While this matter is not yet before the board on the merits, I think it's fair to say that Celebra's petition to confirm its status as an institutional investor essentially will turn on the question of whether, at the end of the day, this board will determine that Celebra is being regulated in Hong Kong under a statute that will be deemed by this board to be substantially similar to applicable U.S. law. Bally has filed a petition to intervene and has attached to that petition a number of documents, including 2 expert reports, which Bally contends on the merits cast doubt on Celebra's claim to a status as an institutional investor. The OEC has taken the position that a question of Celebra's status under Hong Kong law would be a matter of first impression for this board. Notably, the OEC is also supporting Bally's petition to intervene. Despite the fact that it's uncontested that Celebra is the owner of nearly 10% of the shares of Bally's parent, Scientific Games, and the outcome of these and related proceedings could, by Celebra's own admission, cause Celebra to have to divest itself of almost 10% of the shares of Bally's parent. Celebra is opposing Bally's petition to intervene as if Bally had no real interest in this matter. The parties have filed with the board briefs and various statements, stipulations of fact, as well as statements of additional facts. Bally's position is that intervention is left to the sound discretion of this board, and for reasons that both Bally and OEC have identified, Bally is very clearly the kind of party who this board should permit to intervene given the facts of this case, and in particular, Bally's very direct, very substantial, and very immediate connection to the matter of Celebra status before this board. The standards for intervention are well established and are very clearly met in this case. For its part, Celebra is attempting to suggest that the standard for intervention is a very high and demanding one, and one that Bally can't satisfy here. That's not the case. The applicable PA code provides for intervention and proceedings before this board and makes it clear the decision is within the sole discretion of this board. The applicable PA code identifies the factors that this board will consider in exercising its discretion. All of those factors are met in this case, particularly the fact that Bally has an obvious interest in these future proceedings regarding Celebra status, given that those proceedings will directly affect Celebra's continuing status or not as a nearly 10% owner of Bally's parent company. In this case, not only is Bally a party who should be permitted to intervene, but it's also the case that Bally's a party which, as a practical matter, is necessary or indispensable to these proceedings because Bally's rights and status are, as was found by the Supreme Court in the case of Columbia Gas, so directly connected with and affected by this litigation that it must be a party of record in order to protect its own rights. Bally clearly meets all the standards used by this board into guiding this board's discretion to permit intervention. First, Bally's interest in these proceedings is substantial, direct, and immediate. As the cases make clear, what this factor means and what that factor is intended to do is to ensure that a would-be intervener in a proceeding before this board is not connected to the matter only in the vague, abstract way that some member of the general public might theoretically be interested. That's not the case here. Bally's interest here is not merely abstract, but clearly direct, substantial, and immediate, because it relates to the question of the status before this board of a nearly 10% shareholder in Bally's parent company. And if Celebra cannot secure from this board an exemption as an institutional investor, which Bally contends is very significantly in doubt, then Celebra will need to establish its own suitability via a principal entity license application. This is clearly, therefore, not a case in which Bally only has some abstract connection to this matter, like some member of the public might have, but it's an interest that, as to Bally, is substantial, direct, and immediate. Bally's interest is substantial because it is not merely abstract, not merely an interest of the general public, and is real. Bally's interest is direct because there's an obvious and direct connection between this proceeding and Celebra's current and future status, or not, as a substantial shareholder of Bally's parent company. And Bally's interest is immediate because there's a direct causal connection here that's not merely hypothetical or theoretical between this proceeding and, again, Celebra's status, or not, as a nearly 10% owner of Bally's parent. In fact, the case on which Celebra relies so heavily in trying to stop Bally's intervention, the Keystone case, is so different from the facts presented here by Bally that it actually makes Bally's point about why intervention should be permitted. In Keystone, the would-be intervener was an applicant for a license who had been unsuccessful in its application. The applicant never appealed that decision, didn't appeal an award of a license to another applicant, didn't itself hold any license, and yet 3 years later tried to intervene when the licensed party tried to get an extension from this board to permit it to postpone for some time the commencement of actual casino operations. In essence, intervention was denied in that case because it was found that Keystone's interest was really no different than any interest that any member of the general public might have. That's just not a relevant precedent on the facts before this board, and that's the case on which Celebra relies most heavily, if not entirely. In fact, the only thing in that case that Keystone advanced was the argument that if, and I emphasize if, the board were to deny the requested extension, then Keystone might, and I emphasize the word might, later somehow become entitled to a license itself. Not surprisingly, that was held to be too speculative and outside the narrow issue of the extension which was before the board. This present set of circumstances before the board now couldn't be any more different. Two other factors very strongly favor intervention. First, notwithstanding the position of the OEC, notwithstanding the position of Celebra, the matter before the board is complex, likely one of first impression, as noted by the OEC, and very directly goes to Celebra's status not only before this board, but also as a substantial shareholder of Bally's parent. The fact that OEC will be addressing such issues certainly doesn't mean that Bally's participation as an intervener is precluded. And a good example of that is the Sugar House precedent mentioned in our brief, where the board permitted intervention in an issue of market saturation because it was viewed by the board that the intervener was well situated to provide additional information that would guide the board's determination. Finally, Bally also satisfies a third factor, which is that it will be bound by the by the board's ruling regarding Celebra's status. Celebra contends otherwise, but Celebra's argument in that regard is really self-contradictory. Not only would Bally be bound by such a determination, but a decision to permit intervention would in all respects be appropriate, given that it's yet unknown whether Celebra will successfully establish its status as an institutional investor, or failing that will need to establish its suitability as a principal. In either event, those determinations will be binding upon Bally in respect to an issue as critical as the status of a nearly 10% holder of the shares of Bally's parent. Finally, there are two other points of real significance that are relevant here from the submissions of OEC and from Celebra's own submission. In terms of OEC's submission, it's noteworthy that not only does OEC fully support the view that Bally has a substantial direct and immediate interest in this proceeding, but OEC also acknowledges that Bally's intervention, and this is critical, is an intervention designed to protect the integrity of its own license with the board and to ensure the suitability of its shareholder. Clearly, on that basis alone, intervention should be granted. Moreover, OEC makes the point that those interests of Bally are related not exactly the same issue as OEC's interests, which is another reason intervention should be permitted. In terms of Celebra's submission to this board, it's notable that Celebra bases its opposition to Bally's intervention in part by pointing out that one of the possibilities here is that Celebra, a 9.6% owner of Bally's parent, might have to divest itself of those shares. Clearly, viewed properly, that fact alone creates a very real, very substantial, and very immediate interest here on Bally's part. And it's not speculative, since Celebra itself has stated that this is one of the discrete paths this matter may take. For all these reasons, it's respectfully submitted that the board should grant Bally's petition to intervene.
Thank you very much. Office of Enforcement Counsel.
Yes. We maintain our position that we believe that Bally Gaming should be permitted to intervene in this matter, mainly because Bally Gaming is a board-licensed slot machine and table games manufacturer. Celebra is an almost 10% owner of Scientific Games, which is Bally Gaming's parent company, and the petition to confirm institutional investor status was based on its investment in Scientific Games. Bally Gaming is, Celebra in its petition to confirm institutional investor status is seeking a finding from the board that regulation pursuant to Hong Kong law is substantially similar to regulation pursuant to United States law. And we believe that Bally Gaming has met the requirements for intervention as outlined in the regulation.
Okay. Thank you very much. Celebra.
Thank you, Mr. Chairman and members of the Commission. Stephen D. Schreier on behalf of Celebra HK Company. I beg to differ with Mr. Sikura's conclusion that we're relying upon case law, that he's referencing. I think the case law is important to look at, but I think what we're really relying on here in this case and in this particular proceeding are facts. And this proceeding is not about Celebra's suitability. We aren't there yet. That is many steps down the road. This proceeding is about whether or not the regulatory body that licenses and regulates Celebra is substantially similar enough to our United States SEC so that Celebra could be qualified as an institutional investor in the same way as other companies, both in the U.S. and as this board has already found for other countries like the UK. Celebra is an investment advisor firm. You may have that kind of a firm managing your pension account, for example. It's much like the Vanguards of the world, Susquehanna, BlackRock, Fine Capital. All of those firms invest in publicly traded shares on the U.S. markets and in foreign markets as they choose, and they buy these shares openly on the stock exchange, New York Stock Exchange, NASDAQ, foreign exchanges as well. Celebra, at this time, has investments in over 90 different public companies. So it's not just Bally's. Notably, the other firms that I just mentioned each own over 5% of Bally's parent company, Scientific Games. Unlike those firms, my client Celebra is located in Hong Kong. And as you know, Hong Kong is one of the world's greatest financial capitals, along with New York, London, Zurich, Tokyo. That's where they're located. In that jurisdiction, they have an agency called the Securities and Futures Commission. And that commission is designed to be similar to the SEC. It regulates and licenses investment advisors such as Celebra. 2 years ago, not now, 2 years ago, Celebra acquired the 9.6% of the shares that it has in Bally's company. Since then, it had been approved by this board as an institutional investor. And it has been approved as an institutional investor by numerous other gaming states. And in fact, in a state like Nevada, if you have less than 10% of a publicly traded gaming company, you don't have to file anything. Your Gaming Act and your regulations allow you to determine that a passive investor with no ability to control a gaming company can come from another country other than the United States. So at the request of the Office of Enforcement Counsel, the question of Celebra's foreign institutional investor status has been revisited. And as a result of that, Celebra filed its petition asking the board to consider whether the SFC is similar enough to the SEC so that it can be licensed in a similar fashion to the Vanguards and the Susquehannas. If it is determined to be that, it will file the appropriate paperwork as an institutional investor. If it's not, your determination will be that they need to get licensed, and they'll get licensed. I don't understand why this proceeding, which will only end with one or both of those two outcomes, or only one of those outcomes, has anything to do with the company's suitability. No one is sitting here and saying they're unsuitable. Nobody's saying they're divesting any shares because they're unsuitable. The only issue in this proceeding, this particular proceeding, is can we be this or do we have to be that?
Counsel, let me ask a couple of questions, if I may. I think you're starting to reach to the merits because we're here on a very narrow review, and that is the interventional review.
Very good.
And by opposing counsel, it was stated that your client had indicated there might be pathways, depending on the outcome, that would be different from will be licensed or not. We might walk away from the investment, et cetera. Is that so? Is that a pathway that might be one?
Well, I would submit to you that no, I didn't suggest that, and they haven't suggested that. But if they're found unsuitable, usually the outcome, and in fact, Bally's own bylaws require that there be a method of either redeeming their shares or having them divest. Now, Celebra, as an investment advisor, has to make decisions about what it does with its investors' monies. So it's conceivable that they would sell shares, buy more shares, buy less shares, but they are not intending in this proceeding to divest all their shares. They're just asking for you to decide whether they can be an institutional investor or whether they have to go forward and get licensed.
I'd be interested in your specific arguments against the intervention.
Okay, thank you. The three elements that were mentioned are the three eligibility requirements that you have in your regulation to permit somebody to intervene. And you have to meet all three of those elements. And even if you do, then it's up to you, in your discretion, whether or not to grant the intervention. The first element is whether a person has an interest in the proceeding that is substantial, direct, and immediate. I would submit to you that they don't meet any of the criteria. But the first criteria, Bally itself cannot show that the outcome of Celebra's request creates any immediate harm to them in this particular proceeding. How could your ruling in this proceeding, if it goes forward to the end, create any immediate or direct harm if they've held an institutional investor status for 2 years? If you rule in their favor, they will continue to do that. If you rule the other way, then they will have to go forward and get licensed. None of that will be in this proceeding. Your proceeding is only to determine which way they have to go. So there's no immediate harm that will impact Bally in this proceeding. If, in some remote and what I would consider to be speculative set of facts in the future, my client is asked to be licensed and they're found to be unsuitable or they don't cooperate, at that point in the future, there would be a proceeding, I assume, by the board to deal with the suitability. And at that point in time, I would think that Bally would certainly have an interest. But this limited proceeding to decide one way or the other how they should be licensed has no immediate impact. They've held these shares for 2 years. The second prong is whether or not the Office of Enforcement Counsel adequately represents the interest of Bally. And I respectfully submit to you that they do. What has Office of Enforcement Counsel done in response to Celebra's petition? They've objected. They've said in their review of all the information to date leads them to conclude that the SFC is not similar enough to the SEC for investment advisors. And they pointed out in great detail why they believe that to be the case. What does Bally say in its intervention? They object, and they say in great detail why they don't think the SFC is similar to the SEC. It's precisely the same position. So the concept of whether there's an adequate representative for their interest, as required as one of the eligibility criteria, I would submit to you, is covered. OEC has covered it. They're competent, they know what they're doing, and they can respond to the same exact issues, and they, in fact, have as Bally. The third prong is whether the outcome of Celebra's petition will bind Bally to something that impacts it in some way, impacts its suitability or its license. And I submit to you that, again, in this limited proceeding that we've brought, they're not bound by anything. The mere fact that they have a manufacturer's license is not enough. They waive that as if, hey, we have a manufacturer's license, you're an owner. That doesn't meet the eligibility criteria. They can have their opinion. They're an interested party, but they don't meet the eligibility criteria because no matter what your outcome, they won't be harmed in any way. They'll only be harmed in some future potential proceeding if Celebra fails to cooperate or is found unsuitable. But that is not in this proceeding. Bally's can choose who to hire as its executives. It can choose its management team. It can pick its directors, and they have control over that. They have control over those people's licenses. But when you're a publicly traded company, anybody can buy your stock. And those buyers, under certain circumstances like this, are bound by the PGCB's rules or the rules of other gaming jurisdictions as to what kinds of licenses they can get and what kind of treatment they can get as an institutional investor. Bally's can't change that. If you want a license from Celebra, then you'll rule that they have to file one. If you agree instead with a dozen or more other states that they can be an institutional investor at the end of these proceedings, that doesn't bind Bally to take any action either way. Doesn't adversely impact them in any way. It doesn't affect their existing license. So, in sum, I do submit that this board has a fairly high hurdle for intervention. You've chosen, in determining your own regulations over the years, that parties to a proceeding should not necessarily have to deal with others who may have some interest, who may have a very strong interest, in fact, in the proceedings. They have to meet the eligibility criteria. And I submit that in this case, they haven't done so. And if you allow them to intervene, it is going to broaden this proceeding substantially. They've already spent a substantial amount of energy and money on experts' reports and the like, and they will take over this process. That will effectively allow the tail to wag the dog in this particular proceeding. I think their intervention here is premature and unnecessary. They'll suffer no harm by the outcome, and their viewpoint is adequately covered in precisely the same way by the Office of Enforcement Counsel. So I would ask you to deny their petition.
If I could.
Sure.
I wanted to give Bally an opportunity to rebut and then open if there were other questions. If you have some brief rebuttal, please proceed, and then I want to open it up
Very
to
briefly,
questions.
Mr. Chairman, thank you. It makes a lot of sense for this board to have standards governing petitions to intervene. And it makes sense for this board to interpret those standards so as to ensure that members of the general public or people with at most attenuated connections or just a public interest connection to a matter before this board can't intervene. That makes a lot of common sense. But that's not the set of facts here with respect to the relationship here between Celebra, Bally, and Bally's parent. The way I would submit your relevant code sections read is this is a matter entrusted to your discretion. You have some factors to look at to guide that discretion. And in this case, for all the reasons we've set forth in our papers and OEC has set forth in their papers, all those standards are met because at the end of the day, the very clear point made here is that Bally's relationship with all of the issues now before and to be before the board with respect to Celebra is not just a generalized public interest. It's not an outsider looking to intervene in a matter and make it more complicated and make it more difficult and make it more lengthy or make it more expensive. It's just as OEC said. It's an intervention designed to protect the integrity of Bally's license. And on that basis, we think the case law is very solidly in favor of intervention in this matter. Thank you.
Commissioner Ryan.
Mr. Schreier, what is the legal harm that Celebra suffers from permitting Bally's in this matter?
The legal harm, I'm not sure if it would be legal harm, but the harm that I see they suffer is that there is a party who is involved in the proceeding that has a point of view and it's an opinion. And under your standards, that is not a reason to be a party. I would submit to you that if we want opinions, we should get investment companies to come in from here and from foreign locations. We should get gaming companies who have publicly traded shares to come in and sit before you and explain to you why it's important or unimportant that people be able to buy investments from foreign countries and our own country to determine the success of a potential public company. So what I'm saying is Bally's is no different than any other publicly traded gaming company in this particular instance. We are harmed because we are now faced with a question that we were asked to address by your OEC. And that question was, you have been an institutional investor, but we think we need to really examine how you're regulated to determine whether or not you should continue in that capacity. So we have been in that capacity, and now Bally's is attempting, through its own opinions about things, to influence how our status is viewed by the board. And I submit to you, there's a lot of people who would like to influence this board with status of how somebody is viewed, but they don't meet the eligibility requirements.
All right, thank you.
Thank you. We're going to take a very brief recess right now, but we will come back and vote on this matter in the Office of Chief Counsel's portion of the agenda. But just about a 3-minute, 4-minute break. Thank you. Our regular agenda at this time. By way of announcements, the board held an executive session yesterday on November 7th to discuss personnel matters and to conduct quasi-judicial deliberations relating to matters that are being considered today before this board. Next, we have consideration of a motion to approve the minutes and transcripts of the September 13th meeting. May I have such a motion?
Mr. Chairman, I move that the board approve the minutes and transcript of the September 13, 2017 meeting.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Under new business, Executive Director Kevin O'Toole. Kevin?
Good morning, Chairman Barish. Good morning, members of the board. For today's executive session for today's Executive Director's report, I'd like to briefly talk about those two words that are ringing in all of our ears, gambling expansion. So as we all know, Governor Wolf signed House Bill 271 last week, authorizing the legalization of a number of new gaming options in Pennsylvania. Those options include a new class of casino labeled a Category 4 casino, also referred to as a satellite casino. The legislation also authorizes truck stop video gaming terminals, internet gambling, airport gaming, fantasy sports contests, casino simulcasting, and down the road, the possibility of sports wagering in a regulated environment. This bill represents the culmination of a significant effort to expand legalized gaming in many forms across Pennsylvania. The law promises great expansion of economic and employment opportunities for casinos and Pennsylvanians and citizens alike. It also requires extraordinary dedication and commitment of board staff to see that the mandates of the new law are fulfilled. I would like to take this opportunity to express my confidence to you that the staff of the Pennsylvania Gaming Control Board will work diligently to successfully implement the new gaming options. Each bureau of the board will play its part in ensuring the overall regulatory preparedness to reach successful implementations of all the new gaming options. I would also like to thank the board for your leadership, which will be invaluable as we move forward with challenges that this amended Gaming Act brings. Finally, I would like to mention our two legislative liaisons, Dan Stambaugh and Max Flessner, for the hard work that they have done over not only the last several months, but the last several years, trying to keep track of this evolving legislation in order to keep us all well informed. That's my report. Thank you very much, Chairman.
Thanks, Kevin. Next, we will hear from Administrative Director. Any questions or comments from the board at this time? Claire, if you would present, please.
Good morning, Chairman, members of the board. The Office of Human Resources has one motion for your consideration today relative to the hiring of Rebecca Kunkel. Ms. Kunkel has been selected to fill the position of Assistant Chief Counsel in the Office of Chief Counsel. She has completed the PGCB interview process, background investigation, and drug screening, and is recommended for hire by Chief Counsel Sherman. Unless you have any questions, I ask that the board consider a motion to hire Ms. Kunkel as indicated.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applicant as proposed by the Administrative Director.
Second.
All in favor?
Aye.
Aye.
Opposed? The motion's adopted.
Thank you.
Thank you, Claire. Doug Sherman, Chief Counsel.
Good morning, Chairman, members of the board. Today we have two petitions before you for consideration. The first one is the matter which you had just heard oral argument on. The second one will be decided based upon the documents filed of record by agreement of the parties. In each of the matters, however, the board has in advance of this meeting been provided with all documents filed of record. The first petition before the board is that of Bally Gaming's petition to intervene and Celebra HK Company's limited petition to confirm status as an institutional investor. As indicated, oral argument was just heard. The board had held a brief executive session thereafter, and it's now appropriate for the board to consider a motion.
Any questions or comments from the board at this time? May I have a motion?
Mr. Chairman, I move that the board grant Bally Gaming, Inc.'s petition to intervene and that the underlying matter be sent to the board's Office of Hearings and Appeals for the purpose of conducting evidentiary hearings with full participation by all parties.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The second petition before the board today is that of Presque Isle Downs It's a request to terminate a limited shared services agreement between itself and Mountaineer Park, its sister property in West Virginia. Both Presque Isle Downs and Mountaineer Park are subsidiaries of Eldorado Resorts. On May 21, 2014, while both Presque Isle and Mountaineer were owned by MTR Gaming, the board approved a shared service agreement between the two properties, wherein it was agreed that a senior director of player development at Mountaineer would provide similar services to Presque Isle Downs. Eldorado, through Presque Isle Downs, now wishes to terminate that shared service agreement effective November 18th, which happens to be the last day of employment for the current senior director of player development. The Office of Enforcement Counsel has expressed no objection, and it is that request now appropriate for the board's motion.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant, effective November 18, 2017, Presque Isle Downs petition to terminate its shared service agreement with Mountaineer Park as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
And next presenting withdrawals and reports and recommendations is Deputy Chief Counsel Steve Cook.
Morning. The board has received several unopposed petitions to withdraw applications or surrender the credentials of several individuals as follows. The individuals are Bruce S. Bossom, Victor Duarte, Peggy L. Pepper, Michael Fertone, and Peter McGurko. The Office of Enforcement Counsel has reviewed each of these petitions and has no objections to any of the withdrawals or surrenders. And as a result, if the board were inclined to grant same, they'd be doing so without prejudice to each of the requesters. These matters are now right.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board issue orders to grant the withdrawals and surrenders as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next before the board for consideration are 6 reports and recommendations received from the Office of Hearings and Appeals. The reports and recommendations, as well as the complete evidentiary hearing in each of the evidentiary record in each of these matters, has been provided to the board in advance of today's meeting. And additionally, in each case, the person that is subject to the report and recommendation has been notified that the board would be taking the matter up today. If any of these persons are present and wish to address the board, I'd ask them to come forward when their matter is called. The first report and recommendation before the board pertains to Jessica Nicole Flagler. On April 19, 2017, the Office of Enforcement Counsel filed a petition to place Ms. Flagler on the board's exclusion list after it was found that on March 25, 2017, while 19 years old, she attempted to gain access to the Rivers Casino gaming floor utilizing a false identification. Ms. Flagler, along with her mother and grandmother, were escorted to the Pennsylvania State Police office on the casino floor, where she was charged with carrying a fake ID. That charge was later dismissed. Ms. Flagler requested a hearing, which was held before the Board's Office of Hearings and Appeals on August 10, 2017. OEC appeared at that hearing and offered testimony and documentary evidence as to the events at the casino in March. Ms. Flagler appeared at the hearing, testifying on her own behalf and also presenting her mother as a witness. Ms. Flagler admitted that she provided a fake ID, further testified that she had no intent to gamble or drink if she actually got access to the gaming floor, and she also testified that she is currently a student in college, an education major, teaches underprivileged youth in the city of Pittsburgh as part of her education, and has concerns about being placed on the list and the impact it will have on her professional development upon graduation. The hearing officer, taking into consideration all that evidence, subsequently issued a report and recommendation and recommends to the board that, consistent with board practice, that Ms. Flagler be placed on the board's exclusion list until her 22nd birthday, at which time she could petition to come off of the list, and that is the recommendation before the board.
Are there any questions or comments from the board on this matter?
Ms. Flagler's not here.
Apparently not. May I have a motion?
Mr. Chairman, I move that the board table this matter and take it under advisement.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The second report and recommendation before the board today pertains to Juan Morales. In November of 2016, Mr. Morales submitted a renewal application for his gaming employee occupation permit so as to continue working as a security officer at the Sugar House Casino. 3 issues arose relative to Mr. Morales' renewal application, and he was contacted by the Bureau of Investigations and Enforcement on multiple occasions to try to correct deficiencies in his application relative to state and federal taxes as well as to student loan debt. Ultimately, Mr. Morales came into compliance with respect to his federal taxes, but continued to have unresolved issues with the Pennsylvania Department of Revenue and with student loan debt. Due to his failure to cooperate, despite repeated attempts to have him come into compliance, on April 28, 2017, the Office of Enforcement Counsel issued a notice of recommendation of denial of his renewal application. Mr. Morales requested a hearing, which was held on August 2, 2017. OEC appeared at that hearing and offered testimony. Mr. Morales, despite requesting the hearing, did not attend it. Ultimately, hearing only from OEC, a report and recommendation was issued recommending that Mr. Morales' gaming permit renewal application be denied, and that's the recommendation before the board.
Any questions or comments from the board? They have a motion.
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals denying Juan Morales gaming employee occupation permit renewal application as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Devin Kilgariff's report and recommendation is the next matter before the board. On May 2, 2017, the Office of Enforcement Counsel filed a petition to place Ms. Kilgariff on the exclusion list after it was found that on February 3, 2017, while only 20 years old, she attempted to gain access to Mount Airy Casino's gaming floor utilizing a false identification. She was stopped at the entrance, and as a result of her actions, Ms. Kilgariff was charged by the Pennsylvania State Police with carrying a false ID. Ms. Kilgariff requested a hearing on OEC's request to place her on the exclusion list, and it was the hearing was held on July 27th of this few months ago. Both the Office of Enforcement Counsel and Ms. Kilgariff appeared at that hearing. OEC and Ms. Kilgariff presented a stipulation of facts at that point in which Ms. Kilgariff admitted to the conduct that was alleged. She also put on testimony on her own behalf stating that she went to the casino to celebrate her birthday, did not think her decision through or fully comprehend the consequences of going to the casino and presenting a false ID. She further apologized for her actions and requested that she not be placed on the involuntary exclusion list. Notwithstanding this testimony, the report and recommendation that was subsequently issued by the hearing officer recommended that Ms. Kilgariff be placed on the exclusion list for at least 1 year. In fact, consistent with the past practice, if the board were to place her on the list, it should be until at least her 22nd birthday as she remains underage. But notwithstanding that fact, ultimately the recommendation of the hearing officer is that she be placed on the exclusion list, and that's the recommendation.
Just one question I have. Did she actually gamble?
She did not. She was stopped at the entrance.
I see. Are there any other questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board table this matter and take it under advisement.
Second.
All in favor?
Aye.
Aye.
All opposed? The motion's adopted.
Sonia Rudolph's matter is the next report and recommendation before the board. Ms. Rudolph was issued a gaming employee permit during December of 2016 and worked as a security officer at the Rivers Casino. On August 9, 2017, the Office of Enforcement Counsel filed a request for emergency suspension of Ms. Rudolph's permit after receiving notice that she had been arrested and charged with numerous crimes, including felony-graded criminal offenses. The underlying allegations were that on April 29, 2017, Ms. Rudolph, along with several other individuals, engaged in a fight during a wedding reception that they all were attending. Allegedly, Ms. Rudolph assaulted several individuals by striking them as well as throwing various objects. Based on the felony charge, the executive director issued an emergency suspension of Ms. Rudolph's permit, and the matter was referred to the Office of Hearings and Appeals for a hearing. A hearing was held on August 29, 2017, and despite receiving notice, Ms. Rudolph did not attend that hearing. As a result, the only evidence put into the record were OEC's evidence of the criminal charges and underlying affidavit of probable cause, and based on that evidence, the hearing officer recommends that Ms. Rudolph's permit suspension continue.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the suspension of Sonia Rudolph's gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next before the board is Robert Sawyer's report and recommendation recommending denial of his gaming employee application. In October of 2016, Mr. Sawyer submitted an application seeking work as a security officer at the Parks Casino. In May of 2017, the Office of Enforcement Counsel issued a notice recommending denial of Mr. Sawyer's application based upon his criminal history. In his application, Mr. Sawyer indicated that he'd been arrested and charged with assault in July of 2009. However, upon investigation of the application, it was determined that this individual actually had a 25-year criminal history, including numerous felony offenses, and based upon the entirety of that criminal history, OEC recommended him for denial. Mr. Sawyer requested a hearing, which was held on August 3rd of 2017. He did not appear at that hearing. Once again, OEC was the only party present and put into evidence the criminal record at issue. And based upon that evidence, the report and recommendation issued recommends that the application be denied.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals recommending the denial of Robert Sawyer's application for a gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The final report and recommendation before the board today pertains to George Suhar. Mr. Suhar was issued a gaming employee permit in January of 2015 and worked as a security officer at the Lady Luck Casino at Nemacolin. On July 14th of 2017, the Office of Enforcement Counsel filed a request for an emergency suspension of Mr. Suhar's gaming employee permit after receiving notice that he'd been charged with a felony and several summary violations. Specifically, on June 2nd of 2017, Mr. Suhar was pulled over by police after failing to use a turn signal. After interacting with the police officer, a consensual search of his vehicle occurred and a handgun was found. Mr. Suhar informed the police that he did not have a concealed weapons permit, and as a result, he was charged with the felony offense of carrying a concealed weapon without a permit. As a result of that felony charge, the executive director issued the emergency suspension as requested by Enforcement Counsel. A hearing on the validity of the emergency suspension occurred on August 3rd, 2017. OEC and Mr. Suhar attended the hearing, but Mr. Suhar did not provide any mitigating evidence or any evidence at all, really. And as a result, the report and recommendation issued recommends that based upon the felony charge, the suspension continue.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board adopt the report and recommendation issued by the Office of Hearings and Appeal regarding the suspension of George Suhar's gaming employee occupational permit as described by the Office of General Counsel, or Chief Counsel, excuse me.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
And that concludes the matters of the Office of
Thank you
Chief
very
Counsel.
much. Sue Hensel, Bureau of Licensing. Good morning.
Thank you, Chairman Barish and members of the board. Before the board today will be 3 manufacturer renewal applications and 833 principal key gaming and non-gaming employee applicants. In addition, there will be the consideration of 11 gaming service provider applicants. The first matter for your consideration is the renewal of the slot machine and table game manufacturer licenses for Aristocrat Technologies, Inc. Aristocrat Technologies, Inc. is a Nevada-based corporation that manufactures and distributes slot machines and other gaming equipment, including a system utilized with table games. Should the board approve Aristocrat Technologies' table game manufacturer license, the company has asked that the board allow it to pay a reduced licensing renewal fee. Under the Gaming Act, the board may modify the fee for a table game manufacturer if it determines that the fee will unreasonably limit table game devices or associated equipment. Consistent with this provision of the Act, the Bureau of Licensing has adopted a reduced license fee policy which has previously been presented to the board. Under the policy, a reduction of the licensing fee is warranted if there are between 1 and 10 manufacturers of a product and the anticipated sales are under $100,000 over a 12-month period. I note that the policy was based on 3-year renewals, but recent changes to the Gaming Act have extended that term to 5 years, and we are in the process of amending the policy to reflect that change. Aristocrat Technologies is one of fewer than 10 manufacturers of a table game player tracking system. It projects the average yearly gross sales to be under $100,000, and the Bureau of Licensing does monitor actual sales. The Bureau of Licensing recommends that the board grant the request for a reduced licensing fee and recommends that the fee for the 5-year renewal license be $15,000, which is in line with the Bureau's existing policy. The Bureau of Investigations and Enforcement has completed its investigation, and the Bureau of Licensing has provided you with a background investigation and suitability report. I have provided you with a draft order and ask that the board consider the order to approve the table game manufacturer license and the reduced licensing fee, as well as the slot machine manufacturer license. The recommended reduced fee on the table game side does not impact Aristocrat Technologies, Inc.'s slot machine manufacturer renewal license fee, which would be $150,000 for a 5-year period.
And with that, Enforcement Counsel has no objection.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the renewal of Aristocrat Technologies, Inc.'s table game and slot machine manufacturer licenses as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next for your consideration is the renewal of Aristocrat Technologies Australia Pty Limited's slot machine manufacturer license. Aristocrat Australia is an Australian company that manufactures and sells slot machines and associated equipment. The Bureau of Investigations and Enforcement has completed its investigation, and the Bureau of Licensing has provided you with the background investigation and suitability report. I have provided you with a draft order for this entity and ask that the board consider the order to renew the slot machine manufacturer license.
Enforcement Counsel has no objection.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the renewal of Aristocrat Technologies Australia Pty Limited slot machine manufacturer license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Also for your consideration is the approval of principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with an order for 2 principals and 3 key employee licenses, and I ask that the board consider the order approving these licenses.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of principal and key employee licenses as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next, there are temporary principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 5 principals and 18 key employees. I ask that the board consider the order approving these licenses.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of temporary principal and key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
In addition, there are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 568 individuals to whom the Bureau has granted temporary or full occupation permits and 198 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the board consider a motion approving the order.
Enforcement Counsel has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of gaming employee occupation permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Also, there are recommendations of denial for 4 gaming employee applicants and 3 non-gaming employee applicants. In each case, the applicant was notified he or she was being recommended for denial and failed to request a hearing within the specified time frame. The Bureau of Licensing has provided you with orders addressing the applicants who the Office of Enforcement Counsel has recommended for denial. I ask that the board consider a motion approving the denials.
Enforcement Counsel continues to request denial in each instance.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board deny the gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next for your consideration are withdrawal requests for gaming and non-gaming employees. In each case, the permit or registration is no longer required. For today's meeting, I've provided the board with a list of 27 gaming employees and 5 non-gaming employee applicants for withdrawal. I ask that the board consider the orders approving the withdrawals.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the withdrawal of gaming and non-gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next, we have an order to certify the following gaming service providers: Elvin H. Butts, Inc. and TJT, Inc. I ask that the board consider the order approving these gaming service providers for certification.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider certification as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Opposed? Motion's adopted.
Finally, for your consideration, are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 9 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
That concludes the matters of the Bureau of Licensing.
Thank you, Sue. Next up, Office of Enforcement Counsel.
The Office of Enforcement Counsel will present 18 matters for the board's consideration today, consisting of 4 consent agreements, 6 revocations, 1 suspension, and 7 involuntary exclusions. The next 2 matters on the agenda for the board's consideration are consent agreements between the Office of Enforcement Counsel and Category 1 licensee Washington Trotting Association, doing business as the Meadows Racetrack and Casino. The consent agreements will be presented by Assistant Enforcement Counsel Sarah Colasar. Representatives for the Meadows are present, and at this time I would request that those individuals introduce themselves. It's only you today, mister? By yourself?
By myself.
Oh, I'm sorry. Thought you had someone with you. And for the record, and stand and be sworn.
My name is Michael Keelon. I'm Director of Compliance for the Meadows Racetrack and Casino. Keelon. I do.
Thank you.
Good morning, Chairman Barish, members of the board. Sarah Colasar, Kolesar, Assistant Enforcement Counsel for the Office of Enforcement Counsel. This proposed consent agreement involves an unimproved operational plan change in a restricted area which occurred at the Meadows Casino. On February 27, 2017, the Bureau of Casino Compliance observed an employee of the Meadows cutting a hole in the wall between the vault and the kiosk room of the main cage to create an open doorway. The Meadows failed to submit an operational floor plan including this modification. The vault and kiosk room are both restricted areas in the main cage. As a result, the Meadows must submit a request in writing to be approved by the board regarding any modifications of these 2 rooms prior to the commencement of said modifications. At no time prior to this work commencing did the Meadows submit a request in writing to the Office of the Clerk to be approved by the board's executive director regarding this modification. On May 12, 2017, the Meadows completed operational floor plan change 36 after the completion of the above-described modification. Operational floor plan change 36 did include notification of the above-described modification and was ultimately approved on June 2, 2017. At this time, the Office of Enforcement Counsel requests that the board approve this consent agreement between the parties. The terms of the settlement include that within 5 days of the board's order approving this consent agreement, the Meadows Casino shall pay a civil penalty of $7,500. Also within 5 days of the board's order approving this consent agreement, the Meadows shall pay the board $2,500 for the costs incurred by OEC, BIE, and other related staff in connection with this matter. If you have any questions, we would be happy to address them at this time.
Any comments from Washington Trotting?
No, the Washington Trotting Association does not dispute the facts as stated, nor the proposed consent agreement.
Okay. Are there any questions or comments from the board in this matter? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Washington Trotting Association as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. I appreciate your presence. Thank you very much.
This proposed consent agreement involves a self-exclusion violation which occurred at the Meadows Casino. On July 2, 2017, KL, a self-excluded individual, went to the Meadows Casino and actively gamed for approximately 2 hours. During this time, KL attempted to cash out $10,500 in gaming checks at the main cage. According to the cage cashier working at this time, KL did not have the proper identification and the transaction was not completed. Approximately 45 minutes later, KL returned to the main cage to cash out $10,000 in gaming checks. At this time, KL provided his passport to the cage cashier, who made several unsuccessful attempts to enter KL's name into the computer. The cage cashier requested the assistance of her supervisor as she believed her computer was not working properly. The cage cashier supervisor entered KL's information into a different computer and authorized the payment of $10,000 to KL. After KL departed the Meadows, the cage cashier supervisor used the computer to subsequently identify KL as a self-excluded individual. The Meadows promptly reported this violation to the Bureau of Casino Compliance in the Pennsylvania State Police. At this time, the Office of Enforcement Counsel requests that the board approve this consent agreement between the parties. The terms of the settlement include that within 5 days of the board's order approving this consent agreement, the Meadows Casino shall pay a civil penalty of $12,000. Also, within 5 days of the board's order approving this consent agreement, the Meadows shall pay the board $2,500 for the costs incurred by OEC, BIE, and other related staff in connection with this matter. If you have any questions, we would be happy to answer them at this time.
Any comments from Washington
Again,
Trotting?
Mr. Chairman, the Meadows does not dispute the facts as presented, nor do we contest.
Thank you.
Proposed
Any
consent.
questions or comments from the board?
I would have one. Sir, what happened here?
In this particular one, the cage cashier accepted the passport. The passport was for an individual with a Middle Eastern type name. She had difficulty ascertaining what the first name was, what the last name was, which is when she requested the assistance of her supervisor. The supervisor ran into the same issues as far as trying to determine which was which. While the supervisor was trying to figure out what the passport said, the cage cashier continued processing the transaction. The cage cashier completed the transaction prior to the supervisor being able to determine that this was, in fact, a person on the self-exclusion list, and the person had departed.
So, if I can, let me ask, what is the best way to prevent this from happening?
Where the procedure broke down was the cage cashier should not have completed the transaction until this was confirmed, even if it meant that the person would have to wait a period of time, because they wanted to expedite the process, guest services consideration. At that time, they had no belief that the person was on a self-exclusion list. The cashier completed the transaction prior to.
So the problem wasn't with your system?
No, no, it was the procedure.
Okay.
Go ahead.
These were winnings, is that correct?
Yes.
Were they clawed back, or have you attempted to claw them back afterwards?
Once the determination was made that the person was on the self-exclusion list, surveillance attempted to locate the individual, but the individual had departed the casino already. As far as what state police may have done to try and follow through with that, I can't say.
Okay. May I have a motion?
Mr. Chairman, I move the board approve the consent agreement between the Office of Enforcement Counsel and Washington Trotting Association as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Aye.
All opposed? The motion's adopted. Thank you.
Thank you.
The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Gaming Level 2 permittee Priscilla Robles. If Ms. Robles is present, I ask that she come forward and be sworn. The consent agreement will be presented by Assistant Enforcement Counsel James Armstrong.
Chairman, Commissioners, James Armstrong for the Office of Enforcement Counsel. The next matter for the board's consideration is a consent agreement reached between OEC and Priscilla Robles regarding a complaint filed against Ms. Robles to revoke her Gaming Level 2 permit. Commissioners, the Bureau of Casino Compliance referred a regulatory violation to OEC that involved Priscilla Robles, a gaming level 2 permittee, who at the time of this incident was employed as a casino host at Sugar House Casino. A player development executive at Sugar House was checking the playing status of her customers when she noticed one of her customers had an issue with one of her customers' players' cards. The maintenance screen showed that Ms. Robles, through her position as a casino host, had reprinted the customer's player's card. An internal investigation was initiated by Sugar House. Ms. Robles claimed that the patrons requested that their players' cards be prepared in advance. However, patrons advised that they had not been to Sugar House recently and had not made such a request. Sugar House security personnel interviewed Ms. Robles about her involvement in creating players' cards and giving them to unauthorized persons to be used illegally. Ms. Robles denied any wrongdoing, but when offered the choice of immediately resigning from Sugar House or referring the matter to law enforcement, Ms. Robles chose to immediately resign. A subsequent Bureau of Investigations and Enforcement investigation revealed that surveillance coverage of the incident showed a male patron using one of the reprinted players' cards that was issued to a female patron. The male patron was identified as a former Sugar House security officer who advised BIA that on a trip to Sugar House as a patron, he encountered another patron from whom he had known through his previous employment. The patron advised the former security officer that he had received a player's card from Ms. Robles with free play on it and asked the former security officer if he would use the free play for him. The former security officer advised the investigator that he knew Ms. Robles, so he agreed to the other patron's request. The former security officer also advised the BIE investigator that he met the other patron and played the free play on other players' cards given to him by this patron on approximately 4 other occasions. The former security officer also advised BIE that he had no knowledge of any other Sugar House employees making players' cards and using them illegally. It was determined that a total of $775 in unauthorized free slot play was issued by Ms. Robles. Commissioners, through the consent agreement, Ms. Robles acknowledges that while licensed by the board and employed as a casino host at Sugar House Casino, she engaged in unsuitable behavior by producing unrequested players' cards with free play on them and providing the players' cards to Sugar House patrons who were not entitled to them, allowing the unqualified patrons to utilize free play on the players' cards illegally. The terms of the settlement include a provision that Ms. Robles' gaming level 2 permit will be suspended for 1 year. OEC and Ms. Robles request that the board approve the consent agreement. I'll be glad to answer any questions you may have.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Priscilla Robles as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you.
Next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Principal Licensee Robert Soper. At this time, I would ask that Mr. Soper and his legal counsel come forward and introduce themselves for the record. Would also request that Mr. Soper stand and be sworn.
Yes, I do. Good morning. My name is Robert Soper, R-O-B-E-R-T-S-O-P-E-R.
Good morning, Mr. Chairman. William Downey from the firm of Fox Rothschild on behalf of Mr. Soper.
Mr. Soper served in the capacity of CEO, General Manager, and President of Mohegan Sun Pocono from December 2005 to October 2012. He served as President of Mohegan Sun Casino Resort in Connecticut from October 2012 to April 2015, and CEO of Mohegan Tribal Gaming Authority from April 2015 through January 2017. An investigation conducted by the Bureau of Investigations and Enforcement revealed that Mr. Soper failed to update his key applications submitted to the board in August of 2009 and to properly include in principal applications submitted to the board in January 2013 and November 2016 ownership interests in 10 business entities. Schedule H of the board's key and principal applications is entitled Other Assets. Mr. Soper failed to update Schedule H of his 2009 key application and to include in Schedule H of his 2013 and 2016 principal applications his ownership interest in the following business entities: Drinkholder LLC, Jobs LLC, AEI 2008 Venture Investment 1 LLC, Montage Fish Market LLC, Refer Local LLC, Refer Local Business Pages, LLC, Refer Local Classifieds, LLC, Group Capital Holdings, LLC, Path Map, LLC, and Path to French Girls, LLC. It should be noted that Mr. Soper included all relevant ownership interests in the above related business entities in his applicable tax returns and properly included in Schedule B, which is entitled Loans of the appropriate applications, a loan to Jobs LLC, and in Schedule C entitled Securities of the appropriate applications, ownership of shares in AEI 2008 Venture Investment. Additionally, some of the business entities conducted business with Mohegan Sun Pocono. During the time in which Mr. Soper held an ownership interest in Drinkholder LLC, the company did business directly with Mohegan Sun Pocono. Drinkholder LLC entered into a lease agreement with Mohegan Sun Pocono on September 25, 2014, and pursuant to that lease agreement, installed fixtures in the Mohegan Sun Pocono restrooms. Mohegan Sun Pocono did not pay any expenses to Drinkholder LLC or receive any compensation from Drinkholder LLC. However, a business entity in which Mr. Soper had an ownership interest, Path to French Girls LLC, advertised its mobile device app on the Drinkholder fixtures placed in the Mohegan Sun Pocono restrooms. The mobile device app was created by PathMap LLC, another business entity in which Mr. Soper held an ownership interest. Additionally, during the time in which Mr. Soper held ownership interests in the various Refer Local business entities, the companies did a significant amount of business with Mohegan Sun Pocono, beginning in March 2011 and ending in January 2017. Refer Local is in the business of providing discounted offers for various businesses by way of e-commerce and subscriptions. Refer Local's business relationship with Mohegan Sun Pocono consisted of selling vouchers to people on Refer Local's website for what was termed Deal of the Day offers at Mohegan Sun Pocono. The offers included free slot play and a variety of package discounts at Mohegan Sun Pocono. Refer Local would then share with Mohegan Sun Pocono a portion of the gross of any purchases for the Mohegan Sun Pocono offers. Additionally, Refer Local sold a VIP service at Mohegan Sun Pocono, wherein for a monthly fee, patrons were given special benefits and privileges at Mohegan Sun Pocono, such as discounts and quicker restaurant access. Mohegan Sun Pocono also solicited patrons to sign up for Refer Local memberships or offers, and would in return receive a share of the net proceeds of the Mohegan Sun Pocono referred member purchases that occurred on the Refer Local platform. As a result of his ownership in Refer Local, Mr. Soper received approximately $26,945 in total distributions. These distributions occurred during the period of time when Mr. Soper served as president of Mohegan Sun, Connecticut. In 2017, Mr. Soper relinquished his ownership interest in Refer Local for an approximate loss of $73,054. During the time in which Mohegan Sun Pocono and Refer Local companies conducted business, there was no contract or written agreement between them. The Refer Local companies have never been authorized by the board to conduct business in Pennsylvania's gaming industry. Mr. Soper's failure to properly include his ownership interest in the named business entities constitute violations of the Act and board regulations. Mr. Soper's failure in this respect is particularly serious in the case of business entities in which Mohegan Sun Pocono was directly doing business due to the potential appearance of impropriety and conflicts of interest that such relationships could engender. The terms of the consent agreement require that Mr. Soper pay a civil penalty in the amount of $60,000 to the board within 5 days. Mr. Soper must also pay a $2,500 for costs incurred by BIE, OEC, and other staff to the board within 5 days. Mr. Soper shall immediately make the terms of and the conditions of the consent agreement public, and the consent agreement may be set aside if any term is violated by Mr. Soper. With that, OEC requests that the board approve the presented consent agreement.
Thank you, Cyrus. Are there any comments from Mr. Soper or his counsel?
Mr. Chairman, we concur in the recitation of facts as offered by OEC, and we're prepared to answer any questions that the board may have.
Fair enough. Other questions or comments from the board on this matter?
Mr. Soper, are you employed in the casino industry at the present time?
Commissioner, I actually am self-employed. I've created my own company. I am working on a number of projects, both domestically and internationally. Some are gaming, some are non-gaming. Most of them are integrated resort related. So I am technically involved in gaming projects right now.
And where is that business based, sir?
I am based in South Florida, in Sunrise, near Fort Lauderdale.
Thank you.
Are you at liberty to tell us who you are consulting with at this time, who is in the gaming business in the United States?
Yes. I cannot disclose names because I'm under confidentiality with all these projects. One project is in Las Vegas, and it's a major resort there, and I'm working with private equity funds, a international brand, international hotel brand as well. I am also working with various technology companies on launching some online gaming in South America as well. Unfortunately, I am bound by confidentiality as it relates to those relationships.
Any other questions from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Robert Soper as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you.
Thank you for your time.
The next 7 matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel has filed complaints seeking the suspension of 1 gaming employee occupation permit and the revocation of 4 gaming employee occupation permits, 1 gaming level 2 occupation permit, and 1 non-gaming registration issued by the board. Each complaint has been filed with the board's Office of Hearings and Appeal and properly served upon the person named in each complaint. The person named in each complaint failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment and properly served the same upon each named person. Therefore, the facts in each complaint are deemed admitted. All filed documents have been provided to the board, and the matters are presently ripe for board consideration. In each instance, we will provide a brief summary of the facts and request the appropriate board action.
Morning, Mr. Chairman, members of the board. Michael Rowland, ROL A&D with the Office of Enforcement Counsel. The next matter is a request to suspend the gaming employee occupation permit of Gentle Anderson. On March 7th, 2017, Ms. Anderson was arrested by the Philadelphia Police Department and charged with DUI under multiple sections of the Vehicle Code, 2 counts of terroristic threats, 2 counts of simple assault, 2 counts of recklessly endangering another person, 1 count of aggravated assault, 1 count of accidents involving death or personal injury, 1 count of defiant trespass, and 1 count of criminal mischief after she allegedly threatened to kill 2 individuals. Ms. Anderson attempted to strike both individuals with a motor vehicle and successfully hit one of the individuals in a leg. Ms. Anderson has a hearing date set for November 15th, 2017, and the matter is now before the board to consider the suspension of the gaming employee occupation permit of Gentle Anderson.
Questions or comments from the board? Hearing none, is there a motion?
Mr. Chairman, I move that the board approve the suspension of Gentle Anderson's gaming employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next is a request to revoke the gaming employee occupation permit of Ann L. James. On or about July 24th, 2017, it was discovered that Ms. James, a revenue auditor at Sands Casino, allegedly forged refunds worth $4,812 to her personal credit card. This occurred in 10 separate transactions dating back to January 2017. When confronted, Ms. James admitted to taking the identified funds. Ms. James was terminated from Sands and was charged by the Pennsylvania State Police with theft by deception, access device fraud, forgery, and tampering with records. The criminal charges remain pending. The matter is now before the board to consider the revocation of the gaming employee occupation permit of Ann L. James.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Ann L. James's gaming employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Good morning, Chairman, members of the board. Benjamin Farrell, F-E-R-R-E-L-L. The next matter for your consideration is a complaint to revoke Joseph Bennett's G2 employee occupation permit. While employed as a security manager at Valley Forge Casino Resort, Mr. Bennett took a set of golf clubs and a golf bag from the lost and found at the facility. Valley Forge subsequently terminated Mr. Bennett's employment and issued him a permanent eviction notice. At this time, OEC requests the board issue an order revoking Mr. Bennett's G2 employee occupation permit.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Joseph Bennett's gaming level 2 employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter for your consideration is a complaint to revoke Robin Saffone's gaming employee occupation permit. While working her shift as a cage cashier at Harrah's, Philadelphia, Ms. Saffone stole $400 from a cash drawer. The Pennsylvania State Police was notified and charged Ms. Saffone with 1 count each of theft by unlawful taking, receiving stolen property, and disorderly conduct. Ms. Saffone subsequently pled guilty to disorderly conduct and the remaining charges were withdrawn. At this time, OEC requests the board issue an order revoking Ms. Saffone's gaming employee occupation permit.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve the revocation of Robin Saffone's gaming employee occupational permit as described by the Office of Enforcement Counsel.
It's a second.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter for your consideration is a complaint to revoke Melvin Gonke's non-gaming employee registration. While working his shift as an EVS attendant on the gaming floor at Harrah's, Philadelphia, Mr. Gonke stole and cashed out a patron's voucher valued at $55. Mr. Gonke was charged with 1 count of theft by unlawful taking. That charge remains pending. At this time, OEC requests that the board issue an order revoking Mr. Gonke's non-gaming employee registration.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Melvin Gonke's non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Chairman and Commissioners, James Armstrong for the Office of Enforcement Counsel. Next on the agenda for the board's consideration is a complaint to revoke Craig Clark's gaming employee permit for stealing from Sugar House Casino while employed there as a warehouse employee. Mr. Clark was charged with theft offenses and terminated from Sugar House. He is not presently employed in the Pennsylvania gaming industry. Accordingly, OEC requests the board revoke Mr. Clark's gaming employee permit.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Craig Clark's gaming employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you. Next on the agenda for the board's consideration is a complaint to revoke Min Wynn's gaming employee permit for stealing from Sugar House Casino while employed there as a warehouse employee. He was charged with theft offenses and terminated from Sugar House. Mr. Wynn is not presently employed in Pennsylvania's gaming industry. Accordingly, OEC requests the board revoke Mr. Wynn's gaming employee permit.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the revocation of Min Wynn's gaming employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you.
The remaining matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel filed petitions seeking the involuntary exclusion of individuals whose presence in a licensed facility are inimical to the interests of the Commonwealth and are licensed gaming therein. In each instance, the petition for exclusion has been filed with the Board's Office of Hearings and Appeal and probably served upon the individual named in the petition. The individual named in the petition failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment in each instance and properly served the same upon each named individual. Therefore, all facts in each petition are deemed admitted, all filed documents have been provided to the board, and the matters are presently ripe for the board's consideration. In each instance, if the board orders the proposed exclusion, each individual's photo, personal identifiers, and a summary of the inimical conduct will be placed on the board's public website.
Good morning, Chairman, fellow board members. John Pokoneski, P-O-K-I-N-I-E-W-S-K-I, with the Office of Enforcement Counsel. Mr. Chairman, the next two matters are related and arise from the same fact pattern. With permission from the board, I would like to read one fact pattern for both, then request placement on the exclusion list for each individual. On May 19, 2017, William Pratt and Justin Campbell conspired and participated in a robbery of a patron in the parking lot of Lady Luck Casino. On that date, Mr. Pratt and Mr. Campbell followed a Lady Luck patron out to the parking lot, where Mr. Pratt approached the patron while Mr. Campbell proceeded to start his own vehicle. Mr. Pratt then began to assault the patron and attempted to take the patron's money. After this altercation, Mr. Pratt ran to the positioned vehicle operated by Mr. Campbell, who drove away from the scene. Ultimately, Mr. Campbell pled guilty to theft by unlawful taking movable property, a second-degree felony, while the multiple felony charges against Mr. Pratt remain pending at this time. Based on the foregoing, OEC now asks that the board place Justin Campbell on the board's involuntary exclusion list.
Questions or comments from the board? Is there a motion?
Mr. Chairman, I move that the board approve the addition of Justin Dale Campbell to the BGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Again, based on the foregoing fact pattern, OEC asks that the board place William Pratt on the board's involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve the addition of William Pratt to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter for your consideration is a petition to place Tyreek Huff on the board's involuntary exclusion list. On June 18, 2017, Mr. Huff threatened other patrons with a firearm at a blackjack table in Valley Forge Casino Resort. The Pennsylvania State Police was notified and criminally charged Mr. Huff. As of July 17, 2017, 1 count of simple assault and 2 counts of disorderly conduct remain pending against Mr. Huff. At this time, OEC requests that the board issue an order placing Mr. Huff on the involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Tyreek Huff to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter for your consideration is a petition to place Ayev Non Lau on the board's involuntary exclusion list. On February 12, 2017, while at Parks Casino, Ayev Lau passed 7 counterfeit bills at a blackjack table. During his arrest, Mr. Lau was discovered to have a total of 28 counterfeit bills in his possession. The Pennsylvania State Police charged Mr. Lau with 28 counts each of possession of an instrument of a crime with intent and felony forgery. On July 11, 2017, Mr. Lau pled guilty to 1 count of felony forgery. The remaining charges were null prost. At this time, OEC requests that the board issue an order placing Mr. Lau on the involuntary exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Yev Lau to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Good morning, Chairman Barish, members of the board. Dustin Miller on behalf of the Office of Enforcement Counsel. The next matter today is a request for placement on the board's excluded persons list involving Walter Taylor. The Office of Enforcement Counsel filed a petition to place Mr. Taylor on the exclusion list after he was caught cheating while playing blackjack at Parks Casino on February 17, 2017. Based upon the foregoing, the Office of Enforcement Counsel asked that the board place Walter Taylor on the board's excluded persons list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Walter Taylor to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
Opposed? The motion's adopted.
The next matter today is a request for placement on the board's excluded persons list involving Jason Ballard. The Office of Enforcement Counsel filed a petition to place Mr. Ballard on the exclusion list for his involvement in a robbery of a patron of Parks Casino in the parking lot of Parks Casino on December 11, 2016. Mr. Ballard was criminally charged for his actions. Based upon the foregoing, the Office of Enforcement Counsel asked that the board place Jason Ballard on the board's excluded persons list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Jason D. Ballard to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The final matter today is a request for placement on the board's excluded persons list involving Miguel Soto. The Office of Enforcement Counsel filed a petition to place Mr. Soto on the exclusion list for his involvement in a robbery of a patron of Parks Casino in the parking lot of Parks Casino on December 11, 2016. Mr. Soto was criminally charged for his actions. Based upon the foregoing, the Office of Enforcement Counsel asks that the board place Miguel Soto on the board's excluded persons list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Miguel Soto to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you. That concludes our business.
Thank you very much. That concludes today's meeting. Our next scheduled public session will be held on Wednesday, December 13th at 10 a.m. in this room. Is there a motion to adjourn the meeting?
Mr. Chairman, I move the board do now adjourn.
Second.
So be it. All in favor?
Aye.
All opposed? The motion's adopted. Thank you.